Hi there. Welcome to this recording of the webinar Conscientious Protectors, Standing Up for the Earth is Not Criminal. I'm Jojo Mehta, co-founder of the Stop Ecocide Campaign. I'm joined in this webinar by Paul Powlesland, barrister and founder of Lawyers for Nature. Facilitating the questions is Alex from XR Islington. Enjoy.
Having embarked upon a sort of radical practice, practicing law for the earth and founding Lawyers for Nature, I think it was inevitable that I would find myself within the orbit of the Stop Ecocide campaign. I first came across Polly Higgins shortly after I'd done a case involving tree protectors in Sheffield, which I'm going to talk about later on in this webinar, I'm sure. And I read about her in a book by Charles Eisenstein and emailed her out of the blue just saying, I am a barrister who wishes to practice law for the earth. Can I meet you? And Polly, being Polly, said yes. And we had a lovely afternoon in Stroud where we talked all about what it was to be a barrister and to care about the earth. And from there, I then went to a Conscientious Protectors training in Bristol, which is where I first met Jojo, which I think was nearly a year or two ago now. It was 2 years ago, I think, yeah. And have been really interested in this concept because it really is at the frontier of law and politics and activism and care for the earth. And I think it's a very fascinating topic. So that's how we met. And how I only came in sort of 2 years ago. How did the whole idea of Conscientious Protectors come about, Jojo?
So, I mean, the background to this obviously is Polly's long-term work on working towards making ecocide an international crime, which is something that she worked on, as Alex said, from 2009. Actually, I came in somewhat later, started working with Polly in 2014, and I came in from the environmental activist side. I was very involved in the anti-fracking community in the UK. And that's how we first met. And it was very much one of those kindred spirit moments. And I worked with her very closely until she passed away last year. Now, she found over the years that trying to get funding for the work that she was doing to promote the concept of ecocide as an international crime and actually try and move that forward at the diplomatic level was very difficult. NGOs and funders were very wary of it. They thought of it as quite extreme and difficult to predict. And it was very hard for us to get any kind of backing for it. And there's just a few sort of enlightened individuals who helped it to happen. And so there was a kind of realization that if this was going to move forward, it needed to move forward with the support of many, many people. And Polly did have quite a big following. And so what we did was we sort of collaborated on creating a public campaign that could support that work. And Polly's particular brainwave or inspiration, if you like, around that was how to base that campaign, what to base it on. And she said, look, why don't we base it on a document that can actually be used by activists so that, those who are standing up to protect the earth, who are naturally going to be in the same ballpark as those who support making ecocide an international crime, can potentially actually use the document that we base this campaign on. And so through 2016 and 2017, we put together this trust fund document, which was effectively to collect funds to do the diplomatic and legal work. And it's essentially a legal document that you contribute to. When you contribute to the Stop Ecocide campaign, you're contributing funds directly to the work to move the ecocide law forward, which is advocacy work, lobbying, if you like. I mean, sometimes I describe us as kind of the good twin of the kind of evil corporate lobbyists. But at the same time, when you sign up, you're actually signing this document, which doesn't oblige you to anything, but it gives you a kind of proof that you are that you believe that damaging the earth is a crime and that you want to protect the earth. And so as an activist, it also gives you effectively proof that you are acting from your conscience. You're acting for, in good faith from your conscience to protect the earth. And so it's called the Earth Protectors Trust Fund document. And so when you sign up, you're an earth protector by dint of having signed this document. And it allows you to use that in a court of law. And the way that is enabled is the fact that it's been notarized or kind of rubber stamped, if you like, legally rubber stamped right across the world. And that's possibly the first time, well, as far as we know, it's the first time that's ever been done with a document like that. And I don't think it's been done since either. And in fact, when Polly approached the legal firm that arranged all of that, they said, oh, why would you want to do this? They were used to sort of rubber stamping documents for, I know you want to buy a house in Spain and you want to make sure that the document is valid in the UK, for example. But what she was asking them was, can you go to every single jurisdiction in the world and get them all to rubber stamp this document? And they said to her, well, yeah, we probably can. We've never done it before, but it'll probably take us a few weeks and it'll cost you 50 grand. And at the time, Polly had just been donated quite a large sum by somebody towards what she was doing. And she said, you know what, we're just going to do it. And she said to this firm, that's fine, but you have to not ask me for any more. It has to be just that much. And you have to approach every single country in the world. And they agreed to it, and it took them 10 months. I bet they seriously regretted that agreement. But we ended up with this document that effectively had been stamped by every jurisdiction in the world, pretty much. I think Bhutan was one of the only 2 or 3 that couldn't, and it just because it didn't have the infrastructure. But then from what I hear about Bhutan, they're also so happy there that they don't need it. So that's how that all came about.
And I like the fact that it's got a nice story behind it as well. So you have this document. When and how has it been practically used over the last few years? Have you got any examples of where it's been used?
Yeah, absolutely. In fact, one of the first people to use it was actually Gail Bradbrook, co-founder of Extinction Rebellion. And effectively, it's been used by a number of people in the anti-fracking community, and it's also been used by a number of people in Extinction Rebellion. And what we found is that the way that it's been used is as a kind of a supplement to a legal defence that is perhaps more commonly known, like something could be necessity or could be prevention of a crime. And the way that it's used is it allows you to rely on something called freedom of conscience, which is a human right. And it's part of the European Declaration of Human Rights and also the Universal Declaration of Human Rights. And it allows you to act according to your conscience on deeply held beliefs, as long as you're not damaging anybody, basically. And so that right to freedom of conscience is something that was used previously in the 20th century by the conscientious objectors, and we'll come to that in a moment. But what we found in practice is that it allows you to explain why you did what you did. So let's say, you're arrested for obstructing the road. Usually a criminal court would just be interested in whether or not you actually obstructed the road. Now, as an activist, and speaking as one myself, what the activist wants the court to know is not whether or not they were standing in the road, but why they were standing in the road. And that is something that using this approach in court can allow you to do, because you can then say, effectively, I'm relying on my right to freedom of conscience, and my conscience told me that I needed to stand in the road, and therefore you need to understand why that is the case. And then you can present, the evidence or documents or story that you then wish to present. So it kind of opens up the courtroom, if you like, to be able to be another arena for your activism. What it can't do is it can't prevent you from being arrested. And yeah, I mean,
not a get out of jail free card.
No, exactly. It's not a get out of jail free card. And obviously the ultimate aim would be for someone to be acquitted on this basis. That hasn't actually happened yet. So we wouldn't expect anybody to treat it as something that's going to actually, get them off the hook. But that's kind of not the point. So yeah, I mean, I think, Paul's probably experienced a bit of this actually, in terms of how people approach, particularly lawyers actually approach court cases with activists, because there's some interesting questions around that with regard to the conscientious protector approach. What are your thoughts on that, Paul?
Yeah, actually, I made a little note, and I had allows you to say the why, and I triple underlined it, because the why is it's like the word that shall not be spoken in the English legal system. It's they just do not like it. They want to know, did you do this thing, and why you did it. They're just not interested. And that goes for criminal proceedings, but also often injunction proceedings. So I regularly represent activists in injunction cases who want to say, actually, the reason I'm blocking this road is because otherwise they're going to poison an aquifer that supplies 3 million people with water. And I'm just like, oh, I don't care about that. I just want to know if you were sitting in the road or not. And you're sort of looking at being like, so you don't care that that they might poison an aquifer that supplies the water of 3 million people? No, just don't care. But we need to start shifting that. And I think the judges are far behind, but quite a lot of lawyers are too. And I think because lawyers in this country are so imbued with that mindset of just, did they do X, Y, Z, and what is the legal test for this? They have very little time for the why. And I think it's seen as a little bit out there to be a lawyer who cares about the why in these situations, and for people to care about that people are acting according to their conscience. And so I think we're going to go into this later, but there is an issue that many lawyers are not sympathetic to this idea. So if you show them this document, they say, "Oh, this is which case law is this? This is legally binding. This isn't going to work," or and they don't necessarily have these wider thoughts around trying to change the system and to allow people to put forward these expressions and ideas and their ideals in the hope that gradually the system itself might change. And I do find this over obsession with winning each individual case can often be unhelpful when representing activists and when involved in these kind of longer campaigns. I don't know if this is a convenient point to sort of talk about my work in Sheffield a little bit.
Absolutely. I think it's hugely relevant, actually. It'd be great if you could do that.
Yeah. So, that was the first case that I did in this kind of area. So I really cared about trees, and I wanted to see if I could use my skills to protect them. And through a slightly roundabout route via Facebook, I found a group of amazing tree protectors up in Sheffield who were trying to stop thousands of street trees being felled. My first thing I did for them was actually successful. I managed to stop them being arrested by writing an advice. And I then represented them in various cases over the next 2 years. What's interesting is I lost every single one of those. So from a strictly legal point of view, what I did was a failure. And yet, for me, and I think many others recognize now that actually for me, I feel that was the most successful thing I've ever done in my life. And it's actually the work that I'm proudest of. And actually, objectively, what occurred in Sheffield was also a success. Because eventually, after I think 3 years of very hard fought activism,
you're frozen a bit, Paul. Let's just see if you.
Very fascinating about that is it for me is the best example of these two different mindsets. So the law said in that case, the council had the complete right to take those trees down, and not only that.
You froze.
Oh, have I?
Is it, Paul? If you could just wind back a little bit, because I think we missed a section there. Yeah. So go back to the particular case you're talking about.
I'll stop waving my arms so much as well. So stop my video freezing. So for me, it's a perfect example of these two different mindsets. So the council had the complete right to take these trees, and not only that, they managed to get an injunction that made it effectively an imprisonable matter to stand under the tree. So people could be put in prison for 2 years and have their house seized just for standing under a tree peacefully. And so they not only had the legal right to take it, but they had the legal right to put people in prison for trying to resist them. And yet the protectors won, because effectively they recognised something beyond each individual legal case, and that was that controlling a narrative is actually the most important thing. And that's what they did. And they did it in an absolutely sublime way. And every single time the council used the law to try and squash the protesters, they came back peacefully, but insistently, and said, we're not going to stand for that, actually. No, you're not taking these trees. And yes, you can put me in prison if you want to. But they didn't. And, I represented an activist who did breach an injunction. Knowingly, he said, he went on Facebook and said, I'm going to breach this. And he did. And the judge didn't put him in prison, I think because the judge realised that it would look awful and only make the campaign stronger. And that's, I think, in a broader scale, what I see the Conscientious Protectors ideal as aiming towards. It's saying if you act peacefully, but also insistently that you are doing this on the right side and for the right reasons, it makes a very compelling narrative that I think is quite hard to go against. But so from an individual lawyer's perspective, so in the injunction hearings I did, the individual lawyer would just be like, how can I get my client off this individual offence or injunction matter? And my thing was like looking at the wider campaign and saying, actually, because my client who said, I'm going to breach the injunction, and then when it went and did it, he was prepared to go to prison. but he wanted those hearings to be used to extract information from the council and to bring publicity to the campaign and to say, we're doing this and we are effectively a form of conscientious protector. And so it's going beyond each individual legal hearing to say, how can we change a wider narrative? And I feel that's something that's really missing from the system. We have political change and we have legal cases, but there's this very interesting grey area in the middle that I don't think people think about enough, and that I'm really glad that you're thinking about and proposing something towards. So do you want to tell us a bit more about why, bearing all that in mind, why conscientious protectors are needed now, particularly?
Well, I mean, I think it'd be good to just sort of look a little bit at why that particular phrase, conscientious protectors, as well, and I'll come back to why it's needed right now. But just a little bit of background, because it taps in, as of course, you know, many of the listeners will realise, of course, to the whole narrative from the 20th century of conscientious objectors. So people who didn't want to take part in war, either in World War I or in World War II. And it was something that originated mainly with the Quakers. But when people first started making these principled objections to taking part in the war, they were jailed. In fact, some were even shot. It was considered, you know, essentially sort of treason, and it was a jailable offence. But the change of narrative around that stance, the moral change that occurred in terms of how society accepted that over the years between the wars, meant that by the time it got to the Second World War, it was actually a stance that you were allowed to take, and you could do something else instead of actually being sent to the battlefield. So that's a really sort of clear case and a very strong historical example of a change of narrative in society, prompting a change in the judicial approach and ultimately a change in the law. And by the time it got to the late 40s and the Universal Declaration of Human Rights, the freedom of conscience was then included in that Universal Declaration of Human Rights. And that was effectively the result of conscientious objectors objecting on grounds of conscience, not wanting to take part in a harm that they perceived was happening. So the whole idea of taking that narrative and calling it conscientious protectors brings that forward into the 21st century, and it also kind of gives it an extra dimension. And in fact, the whole sort of change of narrative from protesters to protectors is already something that's out there and already something that's being used. I mean, I'm thinking, first thing that springs to mind is the water protectors at Standing Rock, for example. So the idea of protectors is already part of a shift in the narrative that activists are kind of bringing. So to bring in the conscientious side as well, it's kind of bringing two quite strong narratives together, and it has quite an impact in terms of how that taps into what people already feel or already know historically or feel in themselves, because it speaks to a kind of a moral code that we all relate to. And, you know, the way that the current law is set up, it's kind of topsy-turvy. So, you know, we see ecocides happening around the world, mass destruction of the environment, mass destruction of nature, and that seems to be permitted, whereas standing up to protect that nature is criminalised, which just feels completely upside down. So the conscientious protector narrative actually speaks to kind of a realignment of that, and to actually bringing it into line, as indeed at the sort of diplomatic international end, ecocide does. You know, it's kind of realigning that sort of
reframing things as well.
Exactly. It's reframing things, because, you know, I do think that we all have quite a strong intuitive understanding that mass damage to nature is wrong. You know, otherwise why would we be standing up to protect nature? But also this understanding that we are actually all part of this web of life, and that it's ultimately self-defeating to destroy nature, because we utterly depend on what we've got. We're in a closed system planet. This is not you know, a planet of infinite resources. And of course, you know, many indigenous cultures across the world have been trying to tell us this for pretty much ever, that, you know, we are all part of a web of life, and we're actually all an active part. You know, we're not just a random ingredient of that. There's an interconnectedness there that requires consciousness and requires looking after and requires respecting. And that is currently not reflected in Western law, which currently sort of dominates the global legal system. You know, we're incredibly anthropocentric about our law. And, you know, it's like, you know, the great atrocity crimes that are currently governed at the International Criminal Court are all about damaging people, which is not, obviously that's not wrong. Absolutely, those things are crimes. But it's a step to add damage to nature to that, just in the way that it's a step to say that standing up to protect nature is something that is aligned with conscience, but also aligned with the reality that we're dealing with in the world.
Yeah, I was going to pick up on the protectors versus protectors thing. I think I might have got that from you, because I started using it myself. So in my case reports, I started describing it as acting for tree protectors. And I do really much prefer it as a way of talking about it. And again, it's just, and other people picking that up, you know, that's something that everyone here can do. It's just actually just changing the language and letting that kind of sort of ripple out a little bit through society. I also want to pick up actually the First World War example is a really great one, this idea of the way that lawyers approach things. Because you can imagine in a court martial back in 1917, a person saying, I don't want to fight in the war because I think it's wrong. And the lawyer saying, well, actually, unfortunately, that's not a legal excuse. Maybe you should go for, maybe your legs are a bit dodgy, or maybe you've got a job that actually matters. These are all legal things. We can't do this conscientious protectors thing. But of course, if everyone had listened to that and just gone for the kind of get off at any cost thing, the law itself may not have changed. And it was only by standing up and saying something that at the time wasn't actually a legal defense that it then became one. And there's perhaps a paradox there. To what extent you try and work within the law as it currently is versus standing up and actually acting from your conscience. So I really like that example, and it illustrates the lawyer thing that I mentioned earlier. So so why do you think conscientious protectors and that concept is particularly important right now?
So at the moment, and particularly in the UK, the criminal justice system is currently under huge strain, of course, due to the situation with the COVID pandemic. And criminal justice has actually been weighed down the line of priority when it comes to receiving government help. And so the backlog being faced is actually pretty mind-boggling. And this was reported recently in The Guardian. In the Crown Courts, there is a backlog of over 45,000 cases. And then in the magistrates' courts, it's knocking on 500,000 cases, and it's going up. So there's an extraordinary situation at the moment in the UK, particularly with regard to the legal system being very, very much under strain. And I imagine that this may well be the case in some other countries as well. And also bear in mind that the majority of activist offences are so-called summary offences. So they're things like obstructing the road, or there might be trespass, or something that would be seen in the magistrates' courts. So, and also, you know, this session isn't specifically aimed at people that might be wanting to commit more serious offences, although that said, you know, much of what we're saying here would also apply in those cases. So, I mean, the other thing is that the prison system is also massively under strain. So some weeks, you know, prisoners have to be moved between regions just to find a space. And at the same time, you know, additional judges, or recorders as they're known, they're not available to help because of the, you know, the squeeze in the budgets. So, and then of course you've got the social distancing requirements. So that affects jury trials. And in fact, for a time, jury trials weren't allowed at all. They are now allowed again, but the space in most courts isn't adequate, or isn't easily adequate to deal with the number of cases. And so, you know, you're now finding that there are Nightingale courts being opened in either disused court buildings or hotels, or even porter cabins in some cases, to simply provide the space needed to take a trial. So, and there are some various approaches that are being taken to reduce the list of the backed up cases. So, for example, there's greater flexibility in terms of sentencing and sort of custody credit than is normally the case for a guilty plea, for example, so that a higher proportion of cases can be moved through and settled without trial, so to sort of speed things through. And some courts have installed, I mean, it's sort of different court by court, but some courts have installed a sort of a triage system, a bit like a hospital A&E. So you can sort of assess the priority, like how bad is this? And that means that less serious cases can then be moved through more quickly. So, and I mean, there've even been discussions of removing juries from Crown Court trials in some kinds of cases. Like there are some kinds of cases that are called triable either way, because they can either be tried in the magistrates or in the Crown Court, which can depend on the degree of the crime, or it can depend also on what the defendant decides. But for example, allowing judges to reach verdicts on their own in such cases. And although, I mean, there are some historical contexts where that kind of makes sense, like, for example, in the Irish Troubles in Ulster, where juries themselves might be structurally biased one way or another. But as a general rule, judges are pretty much unanimous that they don't want that to happen. They do not want juries to be removed, for straightforward reasons of democracy, justice, and fairness. You know, the whole idea of a jury trial is that you have a selection of lay people who can, collectively make a decision. So that particular approach has not been mandated so far, and it's very unlikely to be accepted by the judiciary. And there have been alternative suggestions of smaller juries, for example, but so far the Ministry of Justice hasn't accepted those. And there's also been proposal of a judge sitting with just 2 lay magistrates, which can happen, for example, if you appeal a magistrates court decision and it goes to Crown Court, that's what you get. You get a judge with 2 lay magistrates. But again, that's extremely unpopular. It's also been rejected and not adopted. So yeah, there's been a lot of adjustments that have had to be made to deal with this extraordinary backlog.
Yeah, and effectively, but there's not that many more adjustments that can be made without fundamentally removing liberties like jury trial and that kind of thing, and the system's at breaking point. So what sort of effect is this having on judges at the moment within the justice system? Well,
I mean, I can only imagine that it's actually pretty sort of, it could be potentially even verging on traumatic, but it's certainly quite heavy going, because what it means is that, inevitably and kind of quite rightly, the priority is going to the trials of, very serious and violent type of offences. So, murders, stabbings, sex cases, abuse cases, these kinds of things. So, judges are kind of dealing with the worst of the worst, one on top of the other. So there's kind of back-to-back horrors going on to a sort of unusual degree at present as well, which just creates an extra level of stress, if you like.
Mm-hmm. And so the system's at breaking point. I mean, it was, to be honest, as a barrister, I realised it was underfunded even before COVID. So this was always going to happen in these kind of circumstances. But what does this then mean for conscientious protectors?
Well, the interesting thing about all of this is it does create a context which can work in favour of new legal arguments. Such as the moral approach of freedom of conscience, because the potential of that depends on new framing and narrative and how widely that new framing and narrative is used. So whether it's by defendants, whether it's by the media, whether it's by the public. So in other words, it's about how many people are talking about activists as conscientious protectors. So it's about actually a shift in the language, in the language that is used around activists and in the framework of how we conceive of that. And so that, there's the sort of moral logic of being a conscientious protector is particularly important, because it sort of, it brings in it sort of, as I say, it kind of taps into that sort of sense of moral rightness that, that obviously the jury must have as well as the rest of us. And there's also already a bit of traction here, as I described earlier, in terms of there have been some cases taken, and actually what we've found is that, although occasionally, we have found that there's been a judge who's just been absolutely, no, I don't want to hear this. Actually, in the larger proportion of cases where defendants have used conscientious protection, the conscientious approach, is that they've actually been given more leeway, more time to speak, more witnesses if they want them, lower sentencing. So there's a whole, there's a bunch of things that have already shown to happen in response to this. And it's also worth, remembering that the principled activist in front of a judge is viewed very differently. The judiciary see them very differently to your average crime. You didn't just go stab someone, you're actually standing up for something that you truly believe in. And that's a very different kind of person to have in front of you. So there's already some traction there. And it's not dissimilar to the situation with conscientious objectors in the 20th century, or indeed with, say, homosexuals in the 20th century. So as society's attitude changes and moral consensus builds, the law has historically been forced to follow. and if not, it's going to be swamped with cases where the alleged criminals are not only not condemned by society, but they're actually supported by society. And the thing is, right now, a build-up of that sort of situation in a system that is already very much stretched, creates a real kind of potential for something to shift in how should we really be dealing with this. Are these people really criminals? Should we really be wasting our court time and public money on this? And it's interesting because Polly Higgins actually observed to Gail Bradbrook, I remember, when we're in discussions around the founding of Extinction Rebellion, actually, because Polly did quite a bit of legal advising at the beginnings of XR. And she said, sometimes you have to break a law to make a law. And that, of course, is what environmental activists engaging in civil disobedience is actually all about. So if mass and damage and destruction, or ecocide effectively, is being permitted and standing up to protect from it is criminalised, then clearly something's wrong. Something has to change. And it can't do so according to the current rules. So it comes back to that paradox that Paul was talking about, that effectively, in order to make a legal defence a valid legal defence, it has to be used as a defence at some point. Otherwise, it's never going to actually become part of that canon. So,
and also probably rejected from a strictly legal point of view for many of the first times it's used, right?
Yeah, exactly. So it's, this is not about winning a case, and it's not about getting off the hook. It's about changing the story that is being told. And, with the criminal justice system in the state it is, if both public awareness and the moral landscape are changing, there is a higher chance than usual that law will need to follow. And of course, this may well be true in other countries as well. And it potentially just has the potential to move faster than it might have in normal circumstances.
Yeah, I represented I did my first criminal trial last year representing Extinction Rebellion activists, and I used some legal defences for them, but actually they told their stories in court as to why they were standing up for the earth, just talking about their children. And honestly, the usher in court cried, some of the barristers, I nearly cried, various barristers were almost in tears. It was really moving, and the judge legally couldn't find on that basis, but he was clearly moved by what they said and basically found them guilty but gave them no punishment effectively. And I can only imagine what difference that is now when you've got judges who are completely under pressure, a system at breaking point where they're struggling to try serious offences involving, GBH, rape and murder, and then you're dealing with people who are like, actually, maybe we shouldn't destroy the earth for our grandchildren. And I can only imagine that it would get an even more welcome reception now than before. But obviously that's in this country particularly. I don't actually know much about the situation elsewhere. Is this applicable all the way across the world? Because we've had, I think, looking at the little message that popped up on our screen earlier, I think we've got many people from all around the world here. So how applicable is it to other places?
Well, it will vary, of course. And this, the points that we've been making, and that there's a few more things to say about it all, but they're made in the context of the UK and potentially other countries where the rule of law is, broadly speaking, respected, which is not necessarily the case everywhere. And activists and protesters here and in other countries, perhaps like the UK, are not, generally speaking, in danger of their lives. So it is in these countries that there is actually the potential for the rising of ecological awareness and the shift in the narrative around protecting the earth. In places like the UK, we have the potential to influence national legal perspectives and in turn to become globally influential. And XR's already shown this in the UK. But there are places in the world where that is not the case. And if the jurisdiction in which you find yourself is not in that position, we are in no way encouraging you to put yourself in any danger. We're well aware that environmental activists in some parts of the world are, very literally in danger of their lives. So we would not want to encourage anybody to put themselves in that kind of danger. I think we can safely say we are not directly instructing anybody to break the law. That would not be an acceptable thing for us to be instructing. And that we're also keenly aware that, even within countries such as the UK, there are still huge differences in how different social groups and different racial groups experience encounters with the police and with the legal system at all levels, actually. So, we're in absolutely no way intending to trivialize that, nor to generalize about it. But what I would say, and I hope this will be an encouragement for wherever you are, regardless of your location in the world, and regardless of your position or whether you choose that position or not, in respect to civil disobedience or to whether you wish to or feel able to engage in it. So regardless of all of that, every single person can help to expand this narrative around conscientious protectors simply by engaging in that conversation and using that framing. And this is really key to shifting legal and political priorities. So just as in the wider Stop Ecocide campaign, we are encouraging people, whether it's NGOs, politicians, civil society, to use the word ecocide, very precisely use that word when describing mass damage and destruction to the earth. We would also encourage people to use the term conscientious protectors to describe those who are peacefully standing up to protect the earth. And, certainly from my perspective, this is really, this is not about, trying to shift to something that doesn't make sense. This is actually about calling a spade and saying what is actually going on. Ecocide, is the killing of our home. That's what the word means. It's the killing of our common home, the earth. And conscientious protectors are standing up on their conscience to protect the earth. So, it really is a very kind of simple way of describing. So yeah, I think it's really important that the language around this is hugely important, just as it was for the conscientious objectors in the 20th century.
Yeah, I think actually genuinely inspired me. I'm going to change my website profile in my barrister chambers to reflect this now. So I'm going to change it from protesters to protectors, and probably try and use the word conscientious protectors, use the word ecocide. Actually, why not? The language we use shapes the world, right? And as you say, some people might not want to go the whole hog of of getting arrested or doing those kind of things, but actually any one of us can begin to shape that language as well. Yeah, I also just added when you're talking about the UK and the sort of danger. I actually find my personal and also professional experience is actually often the process of getting arrested is actually the more horrible one than the justice system itself in many ways. That there is in the UK a latitude given towards peaceful environmental protesters. Many of you may know of the fracking case involving some lorry surfers who were put in jail, and then that was overturned because the judge said, we generally don't jail peaceful protests in this country. So in the UK, at least, there's definite latitude, but obviously, as you say, that's different in other places around the world, and each situation needs to be borne in mind. So if someone wants to be a conscientious protector, is there anything they need to bear in mind? Things that you'd recommend or things to think about?
Yeah, definitely. I mean, if you choose to place yourself in the position of possible arrest and you are wishing specifically to further this narrative, yeah, there are definitely some things to bear in mind in the light of what we've been talking about. So, I mean, the first and foremost, which is in a way blindingly obvious, but it merits saying, any action that you've taken does need to be non-violent. It needs to be peaceful. It can't damage another person. It's impossible to claim a moral stance of conscience if you are causing harm to others. So that's kind of the very, bottom line. And next, I mean, the conscientious protector stance is, I suppose, sort of for obvious reasons, it's more powerful if you plead not guilty. So the whole idea is that standing up for the earth is not criminal. So with regard to the UK specifically, if you're arrested within the next few months, for example, the likelihood of your case actually reaching a court within a year is minimal right now. And this type of case is understandably unlikely to be prioritized in the current situation. So what is more likely is that potentially, you might be offered a caution. Now, a caution is kind of an alternative resolution to a prosecution, which doesn't involve any court proceedings, but it does give you a criminal record. Now, if you accept a caution, you are automatically accepting that you're guilty of a crime, albeit a minor one, generally speaking, with activists. So if you're taking the stance that you're not a criminal but a conscientious protector, your story is going to be a lot more coherent and logical if you refuse a caution. So that's something to be aware of. And also, obviously, bear in mind, I am speaking from the viewpoint of overall narrative, and it doesn't preclude that you may have your own reasons for wishing to accept a caution, and obviously those are completely respected. So one of the points that comes up in the context of this is, traditionally, I'm not sure if one can call it an activist tradition if there are such things, but what I was told, some years ago about getting arrested as an activist is that, you say no comment to everything. Now, actually, that kind of runs a bit counter to what the conscientious protector narrative is trying to do. So we would effectively say, if this is the direction you want to go in, if you're arrested, you actually can state, I am doing this, I'm acting on my conscience, I am taking this action as a conscientious protector, and actually ask the arresting officers to note that down. Because they have, if you ask them to do that, that's what they're supposed to do. And you can have your document that you signed, which you'll get sent to you when you join the Stop Ecocide campaign. You can have that document in your pocket as evidence that you are taking action as a conscientious protector. In other words, you're taking action to prevent harm and not to cause it. And so, yes, the advice would be, effectively, you are maintaining that you're not guilty because you're saying this is not a crime to stand up and protect the earth. So that's a word of caution about cautions. And then a third point, if you do actually get to the stage of appearing in court, and if this does happen, it will likely be a long time hence, certainly in the UK, it's easier to use the conscientious protector line of argument if you represent yourself, rather than having a barrister represent you, for many of the reasons that Paul has outlined.
Putting us out of work, Jojo.
Oh dear, oh dear. Effectively, and one of the reasons for this is that, and this does particularly apply to the UK, I'm afraid I can't speak for other countries, so I don't know exactly how that works in other countries, but certainly in the UK, the judiciary have very strong guidelines as to how to deal with what they call litigants in person, so people who are making their own defence in court. And so why is this route easier? Well, because we've noticed that barristers, as Paul was saying, can be reluctant to use the conscientious protector approach simply because it's not an established legal defence. And indeed, sometimes judges can actually rule out barristers from taking this approach on those grounds, but they can't do that to you. If you are defending yourself, the judiciary has the strong advice that they have to, they almost have to bend over backwards to make sure that you can make your case in the way you want to make it. So although there are no doubt some enterprising barristers like Paul who are willing to push those boundaries, it's actually more powerful and you have more freedom if you are prepared to represent yourself. And that doesn't have to be complex or difficult or have lots of technicalities involved in it. It can simply mean speaking your truth, making your statement as to who you are and what's brought you to this point of taking this action, and potentially providing, if you want, primary evidence to back up why you took that action. So, just as a simple example, if you were taking action on the basis of the climate crisis, you could point to the special IPCC report that says, the 1.5 degrees report, that all countries in the world have acknowledged that certain actions, and emissions lead to certain consequences. You can point to the Paris Agreement, which shows that countries have accepted that that's the case, that effectively there are activities which endanger and exacerbate the climate situation. And you can also point to government inaction and their sort of failure to actually respond to those things and protect the population. So there are some, you can use some quite basic and very public domain documents to make your points, if very simply, if you wish to do so. And there are equivalents for specific kind of, in the cases that we dealt with in the past with, for example, the anti-fracking community, there are documents that you can present that show, that fracking pollutes water and air, for example, and it can be relatively straightforward. You don't have to go into a huge amount of in-depth technical detail. So defending yourself can, when you first think about it, it can feel intimidating, but certainly in the UK, the courts are duty bound to help you do it. And speaking from your heart is very difficult to argue with. And it's also very powerful. And there are cases where man-made climate change has been given legal sort of deeply held belief status, if you like, which is what goes with the whole freedom of conscience thing. If you think about the origins with the Quakers and deeply held beliefs. And of course, conscientious protectors are going that step further. They're not just saying we're seeing the harm and we want no part of it. They're saying we're seeing the harm and we actually feel obliged to stop it because the authorities that ought to be doing so are not doing it. So, you know, and that has a very powerful sort of moral weight, which if you're defending yourself, you have more liberty to provide. So, yeah, so that's another important aspect.
And yeah, I really have a lot of practical experience with that. I mean, you mentioned enterprising barristers like me, but to be honest, there's only so far I can go. You know, I'm bound by certain professional codes, and there's a point where if I try to make an argument that the judge says has no legal weight, he will literally tell me to sit down. If I refuse, then I can basically possibly get professionally struck off or something. And so barristers can only go so far when they're acting for a client. And, you know, I've seen a couple of examples where actually people acting for themselves have been able to really go beyond that. An Extinction Rebellion activist who was in a jury trial and wanted to raise climate change as an issue. And basically the judge said, I'm sorry, you can't raise this. And he's carried on doing it. Now, if that was a barrister, if he'd been represented by a barrister, actually almost instructed me, I would have had to stop. I couldn't go on. But he just carried on. He just kept on doing it. The judge told him, I think, dozens of times that, you know, I've told you, you cannot raise climate change as a defence here. And he just carried on doing it in front of the jury. And the judge's only option there was to basically jail him for contempt or let him carry on talking. So he let him carry on talking. And he got found not guilty by the jury. And actually, had he been represented by a barrister, he may not have been able to put those arguments. And actually, on a very personal level, I had this myself recently. I was able to be my own sort of conscientious protector voice. I got personally named an injunction. A developer wanted to chop down a tree in North London, and because I'd been to the tree and given activist advice, they personally named me, possibly to stop me trying to represent those activists, which is pretty crappy. But because I was actually in person, I was able to talk as an individual, not as a barrister. And actually, it was really a relief. You know, I said to the judge, it's an actual relief to talk from my heart about what I perceive as the complete failure of the English legal system to deal with the climate and ecological crisis. And I had a lovely time, actually. I got to speak from my heart. I got to speak my truth rather than having to wrap it up in all these legal technicalities that, you know, I got to say what I wanted. So even me, who appears in the court all the time, it's actually very interesting to represent yourself and speak your truth. And I think that's what many of us feel. We're headed towards such danger, and the crisis feels so overwhelming that actually being able to speak that truth and say how you feel is actually perhaps some of the most important thing. Yeah. So I think you covered most of the kind of practical elements. What would be the one thing you'd like people to take away from this session, Jojo?
I think if there's one thing we'd love you all to come away from this session with the understanding of, it's really the power of how, as people standing up for the earth, how we describe ourselves and the power of that. So rather than allowing the media or established interests to dictate the framing, which they will given half a chance, it's actually much more powerful to choose the conversation ourselves. So, I mean, especially one that has strong established moral roots, which the conscientious protector narrative does, you know, having its roots with protectors and with the conscientious objectives of the 20th century. So it has got strong moral roots, and that makes it very powerful. And so telling that story, you know, regardless, you know, even if you never plan to take part in any on the ground action, using that language and framing things in that way has a hugely powerful potential. So I think that if there's kind of one point that, you know, we'd want to be a sort of takeaway from this session, it is that. And it's that calling, it's that moral kind of calling to the conscience and using that language around it. So yeah, I think it has extraordinary potential. And as you know, I went into earlier about the UK court system, you know, now is a very interesting moment to be really amplifying that particular conversation.
Yeah. I think we're handing back over to Alex now, aren't we, for some questions?
Go for it, Alex. Switch yourself on.
I've been busy talking, so I think there's been various questions. Oh, there's 29 questions wrapped up in the Q&A. So,
wow. Well, we might not have time for all of them.
Their importance as upvoted by others. So if you want to upvote something, please go on now to Q&A, and you just upvote by hitting the thumbs up button beside the question or underneath the question.
Should we give people a moment to vote?
At the moment, there's one at the top. So shall I just read?
Let's start with that.
From John. he says, could you explain a bit more on how criminalising ecocide at the international level would translate effectively into protection at the local level, given international crimes historically hasn't been tremendously effective?
Yeah, no, that's a really good question. And there's actually a bit of a difference. There are a couple of differences between potentially making ecocide an international crime and the atrocity crimes that are currently governed by the International Criminal Court. So war crimes, genocide, crimes against humanity, and crimes of aggression. So the first one is the sort of nature of it. Ecocide is generally a corporate crime. I mean, of course, there are plenty of state-sponsored corporations, but essentially those who are committing ecocide or mass damage and destruction of ecosystems are mostly corporations. And what that means is that there's a different kind of sort of moral sense around it. Now, I mean, what's the best way to explain this? I suppose, quite simply speaking, CEOs care very deeply what people think of them. I'm not convinced that genocidal maniacs do. So there's a big difference. You know, if you're a war criminal, you are probably not waiting to see whether people think it's a good idea. That's what you're doing, right? But as a CEO, your company value depends directly on public and investor confidence. So putting ecocide alongside genocide, for example, as an international crime, puts the controlling minds those in charge of decisions which lead to, say, mass deforestation or the poisoning of a whole river system, or all of that, puts them on the par with a war criminal or with a genocidal maniac. And that's really not where your average CEO wants to sit. Whether it's a head of a bank, whether it's the head of BP or Shell, it doesn't matter. They don't want to be seen that way. So there's a much stronger deterrent power to it. So that's one aspect. Another aspect that makes it different from other international crimes is that, I mean, you may be aware that the International Criminal Court acts as a court of last resort. It's supposed to act as a court of last resort. So when if you have a crime at the International Criminal Court, those countries which are members of the court and which ratify that crime have to apply that crime within their own jurisdictions. Now, with something like war crimes, you've got a situation where, if your head of state is making war and you want to take them to court about it, it's virtually impossible to take them to court in their own country. So you're almost by default, you're going to end up at the International Criminal Court. With ecocide, that's not the case. What has the potential to happen with ecocide is that, the countries that ratify it will end up running trials in their own countries. So in a way, it gives the International Criminal Court the opportunity to act the way it was always intended to act, which is as a court of last resort. So, effectively, it allows you, assuming that it's passed. I mean, let's say the UK ratifies it. I mean, I must admit, I don't expect the UK to be first in line to ratify this from their current record, but let's say they did. You would then be able to tap any policeman on the shoulder and say, I'd like to report a crime of ecocide. You don't need to go to a special court somewhere, or, it just becomes part of the criminal justice system. I'm not sure if that completely answers your question, but I hope it goes some way to doing so.
If it does,
there's another element, which I think is what we're here to talk about today, which is that by the Stop Ecocide campaign bringing in this notion of conscientious protectors, and what I love about it personally, because actually as a person, I find it very difficult to work on these very long-term international scales that you and Polly have worked on. I need something really tangible and immediate, like, oh, this tree, this river, and I know many others do as well. And that's exactly what this conscientious protector idea is designed. It's not saying that ecocide is something that's going to happen far away, and that you have to go to the International Court of Justice or even to the courts in this country. It's saying, actually, right now, in whatever form of nature that calls to you, you can go and protect it. You can be a voice for nature, and you can be a voice of stopping ecocide on a very small scale. And that's what I love about this, is anyone on this call can choose a river or a tree or a hedge or a woodland or whatever it is that personally calls to them in their heart, and say, actually, I'm going to protect that peacefully, but I am going to protect it, and I'm going to be a conscientious protector. And that's what I love about this. It's really empowering for people. We don't have to wait for somebody else to do it.
Thank you. The next question is, could the speakers, and this is from Maurice Luffman, could the speakers discuss HS2, please? And I know this is a biggie.
Well, it's interesting actually, because I was invited to speak to some MPs in Westminster last year during the time when the rebellion was going on in London. And what I found interesting, and to talk to them about ecocide law, and what I found interesting was that they found it very difficult to kind of really grasp the fundamental nature of how putting in place a law of ecocide would change what projects governments take on. And they did actually bring up HS2, and one of them even asked me, could we pass this law and still build HS2? And and I was like, well, probably not, because when it comes to it, okay, one of the things about ecocide as a concept, it is about mass damage and destruction. So it's in terms of the criminality of that, we're not talking about potentially the trees on your village green. We're talking about something of a bigger scale that's either systematic or very severe or long term. But frankly, HS2 is in that category. We're not talking about one little bit of woodland that disappears. We're talking about over 100 ancient, irreplaceable woodlands. I would say that were ecocide crime currently in place, yes, that would probably fall into that category. And I would say that those conscientious protectors who are standing up to object to what is happening with HS2 could very, very well say we are protecting against what should be an ecocide. So I think that it's very much the kind of ecocide of the moment in the UK, I would say. I mean, I don't know what you think about that, Paul.
Yeah, I mean, I'd almost like a little bit more guidance on that question, because I could probably fill the rest of the time with talking about HS2. I've been representing anti-HS2 activists in court for over 2 years now, and it's obviously I do it with an open heart, but it's also quite depressing because HS2 has law and money and power on its side, and is committing huge destruction, and it's really depressing to see that. But also, there are people who are standing up, and actually my example about, I mentioned the aquifer earlier and how the law doesn't care about the why, that's actually from a HS2 case. I think that same activist has raised that point, I think 4 or 5 times, different hearings now, and every time the judge just doesn't listen, but every time she carries on raising it, and I think there's something quite powerful in that. I think it's an interesting example actually of conscientious protection, in the sense that, as I say, legally HS2 has authorization to act. Legally, they can basically do all of this stuff in terms of law as it is at the moment. But I think more and more people are realizing, from a moral point of view and from a protection of nature point of view, that it's completely unacceptable, and are standing up and being counted about that. So,
thanks, guys. And I would add that today's story of the 250-year-old wild pear tree, could that be an instance of conscientious protector? Could you protect one tree within a wider?
I mean, this protecting one tree is really it's my jam, really. I mean, I personally feel almost more. I think this is often a very personal thing. I actually feel often more of a connection to those kind of things than wider systemic issues. And I know the wider systemic ones are more important, but for me, the tree I mentioned where I personally got injuncted, I went to see the activist, but actually I went and just spent, and just bring out the hippie barrister in me, but I went and hugged the tree and spent a bit of time and touched it and said, I will do what I can to protect you, and I have. And actually, I think, in some ways, having that connection with one tree or one river is a very powerful form of conscientious protection. And I would urge you, if you feel that slightly hippie thing, to go and actually, have that moment with a tree or with a river and pledge that you will do whatever peaceful is necessary to protect it. There is a power in that, I think.
Okay, thank you. And the next question is, what stage is ecocide at now to becoming law? And I think this goes first to you, Jojo.
Yeah, okay, so that's a bit of a kind of general update about where we are with the campaign, which it was great to get the chance to do that. So if you've been sort of following this narrative at all in terms of our social media feeds and newsletters and so on, you'll know that the last few months have seen a massive acceleration in both people talking about ecocide, but also states professing interest and so on. So we had in December, we had 2 small island states that actually called for serious consideration of adding ecocide to the Rome Statute at the International Criminal Court. And that was the first time in nearly 50 years that a state, representative had made that kind of state, had talked about ecocide, in an international forum in that way. And there's sort of 3 years of work behind that in terms of, supporting those islands and working with them. And obviously they were courageous enough to actually step up and ask for that. And it may seem like a small thing, but actually it moved the whole conversation onto another level. It's now a conversation that is happening between, at the international state level, which it has not been for nearly 50 years. So that was pretty exciting. And then earlier this year, the workers' movement in Sweden, so the trade union movement, actually issued a statement where they were requesting their own government to be, to lead on taking ecocide crime forward at the International Criminal Court. And that's really interesting too, because it brings in the whole thing that, the media have been very keen in the past on kind of opposing jobs and nature and saying, you can have a nice environment or you can have jobs, but you can't have both. And actually the fact that the trade union movement is starting to get behind a crime of ecocide, that they've been saying for some while now, no jobs on a dead planet and so on, that's another kind of major awareness raising. And then of course there's what happened in France, and this I think really echoes with the drive of Extinction Rebellion towards citizens' assemblies, because it was a French citizens' assembly, the Assembly on Climate, which actually in their case it was actually convened directly by Macron, by the government, where there was a whole situation which you probably recall with the Gilets jaunes, where the fuel tax was raised and there was a big popular uprising about it, and the French government pretty much said, okay, fine, you don't like our climate policies, you put some climate policies together. And so these 150 randomly selected citizens were created we were brought together in this climate assembly, and they came up with 149 propositions, and top of that list was making ecocide a crime. And so that was pretty incredible, because what that showed was that if you put the right information, people are able to weigh up that information, actually most people will say, no, we should not be destroying the environment at the rate we're doing. And that's, that narrative has been building in France over some time, but I think Macron in a way found himself cornered by his own, by the government's own decisions to bring that citizens' assembly, because that week as well they had a big sort of swing towards the Greens in their local elections, and so when it came to responding to that citizens' assembly, Macron was pretty much hands tied to say that he thought it was a good idea. So he's now said that they're going to consider incorporating the principle into French law. But he also, very importantly for us, said that he would champion ecocide at the international level so that leaders could be held accountable at the International Criminal Court. And that is hugely powerful. And literally right on the heels of that, we had the Greens in Belgium introducing a bill into the Belgian Parliament. So, this is starting to really gather momentum now. And, it could even be as early as next year that we end up with a situation where there's a state or group of states actually willing to propose it. So, that would be quite fast, but it's not beyond the realms of possibility now. Whereas a year ago, we couldn't have even imagined that would happen. So, and a lot of that is to do with, again, talking about it. And we realise that the scale of time that we're dealing with in terms of dealing with the climate and ecological crisis, we don't have time to get the entire world on board with our particular campaign, although obviously the more people we can, the better. But what we have, what we can do, and what, in a sense, what we must do is have everybody, all the environmental NGOs, all, politicians, civil society, all talking about ecocide, because that is what brings it into the consciousness of politicians, and the realization that this is something that they can actually do and move forward with. And if they do it at the international level, it's actually less politically risky, because they don't necessarily have to change their own law tomorrow. They can know that by supporting it and it moving forward at the international level, that when it happens with lots of countries together. And so there's a kind of solidarity, and there's less of a fear of putting, established economic relationships, into jeopardy.
Okay, thank you, Jo. Paul, have you got anything to add on that?
No, I think that's definitely Jojo's territory.
The next question, and it's from someone who would prefer to be anonymous. How can we charge a CEO on ecocide?
Well, I mean, right now you can't, unless you're in one of the few countries where ecocide does exist as part of the penal code. There are a few, mostly ex-Soviet countries, and sadly, mostly, also countries that don't necessarily have a great reputation for enforcing those kinds of laws, and also potentially corruption issues. But so effectively, in most countries in the world right now, you can't. But once ecocide is in place as a crime, there would be, those CEOs would be able to be held accountable in the countries where the crime has been ratified, so long as in a couple of different circumstances. So if they're actually from that country, or if someone who is in charge of the operation that is ecocidal in some way is from that country, or if the victims are from that country. And also there's also the possibility, and this is something that's very interesting in the light of Belgium being interested in discussing ecocide law, is that if you operate universal jurisdiction, then potentially you can arrest anyone from anywhere for a crime, so long as it exists and you consider it serious enough, and so long as the perpetrator is on your territory. So an example of that would be General Pinochet at the end of the 90s in the UK, who was arrested. The warrant came from a Spanish judge who we actually work with, a guy called Baltasar Garzón, and he was arrested in the UK. Now he was actually the dictator from Chile. And he said, well, you can't arrest me for torture or crimes against humanity, because we're not signed up to the torture convention, or the convention that applied. But the UK Supreme Court actually decided that actually yes we can, because you're on our territory and we subscribe to it. So there's also this kind of possibility of having this apply even to countries or nationals of countries who don't currently belong to the International Criminal Court. So for example, America or China. So it does have this kind of marginalizing effect. And as I said earlier, when a country has ratified a crime at the International Criminal Court, a year later, it becomes part of their own law. So in the UK, the International Criminal Court Act basically brings war crimes, crimes against humanity, and genocide into the UK criminal justice system, pretty much word for word as they are at the International Criminal Court. So there's the possibility, at least in theory, as I said, of tapping a policeman on the shoulder and reporting a CEO.
Nice. Thank you, Jojo. And Paul, have you got anything to add?
Not so much on the legal part. I think this is maybe going back to this idea of narrative shifting, is that I think if we begin to shift the narrative and we begin to use this language more, it will also, I think, have a chilling effect on the ecocidal actions of corporations and those who run them. Because saying, oh, it wasn't a crime when I did it, might not be enough. And actually, I think the CEOs who are in charge of companies that are doing things which they know are going to lead to the runaway climate change and massive ecocide destruction, and frankly a form of genocide, the deaths of millions of people, and they know it. I think those people should be worried, and I think the more we manage to bring about this narrative, the more worried they will be, and perhaps they will begin to shift their actions even before any law is brought in, on the worry that it might be. So
yeah, I think there's also something to look at there in terms of, I mean, when you bring a criminal law in, it doesn't generally act retrospectively, but actually there's a way that also works to the advantage of bringing ecocide into place, because as Paul said, you're going to start, when this appears on the horizon, which it is now starting to do, even when it appears on the horizon, those people who know that they're taking part in those activities and that they're giving permissions or issuing orders, etc., they're going to start becoming wary, and the very fact that there is a procedure for going ahead and amending international law almost kind of creates this kind of transition period, like a kind of compliance period. I mean, most people here will remember when the GDPR, the data protection regulations came in. There was this kind of period where everybody knew that at a certain date those regulations were going to come in, and so everyone's like scrabbling to get themselves compliant with that law that's coming in, and that's exactly the effect that we want with ecocide. And and again, that comes down, as Paul was saying, to it comes down to two things. It comes down to the procedure being set in motion, of course, but it also comes down to how many people are talking about it. How inevitable are we making this?
Okay, thank you very much. We've got about 15 minutes left, and I want to make sure that we answer all the questions. And I think, Paul, this one might be for you more than Jojo.
Okay.
From Peter Golden. And he says, might the UK follow the Bolivian model of a law of the rights of Mother Earth? And he goes on to say, it enshrines rights to life, diversity of life, water, clean air, equilibrium, restoration, and pollution-free living. And I think this is also a law that's somehow made in Costa Rica.
Yeah, I mean, there's a number of examples of granting what we would call legal personhood to nature around the world. The question is, yes, it might. Chances of it happening anytime soon in the UK? Probably quite slim. Even really minor attempts to do this. So the local people tried to get rights to the River Frome by passing a bylaw, and it was actually vetoed by DEFRA, who said it was too radical and weird, basically. And now they're having to appeal that. So I think the chances of there being, the Rights of Rivers Act 2025 or the Rights of Trees Act, even 2030, is probably a bit slim in the UK, although obviously maybe things can change. In some ways, the better example, actually, I think, for this country is...
Oh, poorly frozen. Jojo, have you got
actually on the UK one?
You're back. Paul, you froze for a moment there. Do you want to just rewind 30 seconds?
Sorry. Yeah, so I was saying the more interesting example is almost the New Zealand one. So the Whanganui River has rights. And I like that because the New Zealand system is closer to the English one than almost any other. It's largely based on English law, and it shows that even in that kind of system, you can give rights to nature. But the key question is, how do we do that practically? And I also feel if we're just waiting for the UK to pass that kind of law as an act of parliament, then I think we could be waiting quite a long time, and we don't have that amount of time. And so for me, rights of nature, again, it's this shifting a narrative. In this country, the crucial thing I'd say in the UK is to have people that care about the natural world and are willing to uphold its rights. And that can also create those rights. So this goes back into the conversation right at the start we had about what is this sort of weird...
You're frozen again, Paul.
Very interesting.
I don't know, hundreds of thousands of people
You froze there, Paul.
Yeah, you froze again.
Sorry.
It's the hand gestures. So when you stopped at how do we create those rights?
Okay, the crucial point.
The cliffhanger.
How do we create those rights? Well, imagine if there were hundreds of thousands of people who were committed to upholding the rights of trees not to be destroyed or rivers to be polluted, even under the current legal system. I think that would make a massive difference. And that's what we saw in Sheffield, right? The trees had no legal right to remain, but a couple of thousand people said, I believe these trees have the right to remain here. And the law basically couldn't enforce it against those people. And I've got that myself. I've set up a group of people to try and restore a river in East London. And we're just using the current legal framework to try and stop pollution, to stop litter, and to try and uphold the rights of the river. Imagine how powerful it would be if every river in the UK had a group of citizens committed to upholding its rights. They could declare those rights and just say, we're going to uphold them. Under the current legal system, because actually there's quite a few laws we can already use, but actually if the law isn't good enough already, we're going to still uphold them. You're not polluting this river. You're not going to put rubbish in this river. We are going to rewild it. We are going to reforest it and restore it. That would, in its own way, give rights to rivers. And then maybe Parliament would have to catch up. And it almost exactly tacks on to what you were saying earlier, Jojo, about this idea of the law having to catch up with them. And that's, I think, rights of nature as well is one of those things where we can't wait for it.
I think that's really important, actually, and it's interesting how that rights of nature relates to ecocide law. It's kind of two sides of the same coin in a way, because you can have a right to life, but if there isn't a crime of murder, then your right to life isn't worth so much. And in the same way, you can have, nature can have rights, but unless there's a crime against damaging nature, i.e. ecocide, then it's not always easy to protect those rights. So criminal law and the rights the rights discourse are kind of the rights and responsibilities sides of the same coin, if you like. But I also think there's a timeline involved, which it relates a bit to what Paul was just saying. in the sense that, you know, with ecocide crime, you're potentially dropping a new crime into a system that already exists. Whereas with rights of nature, the practicalities are different, because you're actually looking at shifting the entire basis of the legal system. So in terms of a kind of, you know, a legal feat, that's actually far bigger and far more ambitious. So in a way, we still see ecocide as being almost a step in that direction, because once you criminalize serious damage and destruction to nature, you're putting that on a crime with a serious and damage and destruction of people. So let's say, you know, you're putting, you know, ecocide next to genocide or whatever. You're basically, what you're doing is you're shifting the concept in people's minds. So you're saying, okay, so if damage to nature is equivalent to damaging people, in other words, it's really bad as well, then doesn't that mean that nature's status is different in law to how we've currently been treating it? So it kind of, it is a bit of a bridging piece as well, the way we see it, that could be pretty powerful.
And the crucial thing is, it's the idea of right to nature is entirely shifting how our society perceives legal rights, and those shifts have happened in the past. You know, we've gone from, in 2,000 years ago, only rich white men had rights, to you know, basically all humans ostensibly having rights now. But those shifts often took a long time. You know, the shift to end slavery and give rights to slaves took 30, 40 years. Do we have that time right now to do this for nature? Probably not in a top-down way, and that's why it needs to be, I think, needs to come in from lots of different angles, I guess, both the ecocide one and also the grassroots one, which is where I see conscientious protection coming in.
Thanks, guys. I'm going to move us along now, because plenty of people have got questions, and here's an interesting one from Peter Golden. Does religious conscience have influence in UK courts? Pope Francis has called for ecocide to be recognised as the 5th category of crime against peace in the Rome Statute.
Yes, he has. And I mean, obviously, and actually it's funny, it's an interesting mixture of the two things we've been discussing, in terms of ecocide and conscientious protection, because the freedom of conscience provision in the Universal Declaration of Human Rights actually did come from a religious stance, you know, the Quaker pacifist stance. So, you know, yes, in that respect, in terms of the right to freedom of conscience, yes, you know, religion or deeply held belief is taken into consideration. I mean, under criminal law, I'm not sure that works in quite the same way. But what I find interesting, and I mean, this is simply really an observation, but I think it's an important one right now. I find it's an interesting irony that faith leaders like the Pope and, you know, indigenous leaders and shamans are pointing out to us a reality, which is that, you know, a factual physical reality, which is that we are completely interdependent with nature. And at the same time, materialist politicians who, you know, are supposedly, you know, acting on the facts, etc., are actually operating on complete blind faith in, you know, constant GDP growth, for example. You know, you've got this sort of really strange contrast going on. And I think one of the interesting things with this is that, you know, it's still relatively unusual to hear law discussed amongst the, you know, the environmental conversation. It's only really in the last year or so that has started to happen. And, you know, criminal law is still not the first thing that's considered. It's always economic stuff. I mean, if you look at the, you know, the COP talks, you know, it's all about ambition and how we can get companies to do X, Y, or Z, or, you know, how we can incentivize them to do these different things. I mean, there's no incentive like a possible, you know, 10 years behind bars to have you do something different with your corporation. You know, and that's not really being talked about. And I think that, you know, we're also looking at a situation where there are plenty of corporations who would like to do the right thing, and there are plenty of ways of looking at things. I mean, I'm thinking of Kate Raworth's donut economics. I'm thinking of Bill McDonough's cradle to cradle. I'm thinking of Ellen MacArthur's circular economy, you know, and you know, the whole sort of biomimicry movement. There's a huge amount out there, you know, of people wanting to do the right thing. But because the funds keep getting, you know, siphoned off to the ecocidal activities, really hard for those things to gain traction. And as Christiana Figueres, who brokered the Paris Agreement, has said, you know, corporations are starting to move in the right direction, but they're doing it at a snail's pace compared to what we need to happen. Again, it comes down to that timescale thing. And actually, if we're going to shift that narrative, you know, it's about, if we can put ecocide law in place, we have a kind of corrective, like a course correction or a safeguard that gets put in place so that those things can start happening, you know, more rapidly. And I think the faith leaders have a very key role to play in this, because they have such influence over people's hearts and minds. I mean, you know, when it comes down to it, the Pope is probably the single most influential figure in the world in terms of the number of people he has the potential to influence. It's like 1.2 billion or something like this in terms of his personal ability to reach. And, you know, one of the things that we would absolutely love to see and are kind of working on in a way is you know, can we get to a stage where, you know, the Pope is not just urging, you know, leaders, but also the whole Catholic community to get behind, you know, actually criminalising damage to nature, the same way that he did when he announced it to the legal conference in November. So, and similarly, you know, the other faith leaders as well, because all the faiths have some kind of stipulation for looking after creation. And of course, with the indigenous cultures, it's even more visceral than that. It's, you know, I spoke in New York last year, and there was an Ecuadorian shaman there, and he said afterwards, you know, you're speaking our language. You know, we consider that if a river is destroyed, that's like destroying our people. You know, there is no difference for us. You know, we are relatives. And so, you know, that aspect, that religious aspect, is absolutely fundamental, I think, in terms of this shift in narrative.
Okay, thank you, Jojo. Paul, anything to add on that? Otherwise, we've got another question. If this one's from Claire Nevin. Sorry, I didn't give you a chance, Paul.
No, it's fine.
Claire Nevin asks, could a lawyer who's usually bound by the cab rank rule, i.e. the rule that you have to take a case in order, just to explain to those who don't know, could that lawyer use the conscientious protector idea to refuse to take certain cases if they are facilitating environmental harm?
I think that one comes to me, doesn't it? Yeah, I mean, it's interesting. Again, I don't know under the current regulations whether that would be allowed. I was actually thinking about this in the last week. The cab rank rule is, you know, that's me having to represent someone who's destroying the earth. It doesn't sit easily with me, but that's what my profession apparently demands. And I was actually one of those different ways, and one of them might be what's called conflict. So you can't represent someone if there'd be a conflict there. So, for instance, if someone had murdered one of my family members, I couldn't represent them because I wouldn't be able to represent them to my best of my ability effectively. That's the conflict rule. And actually, I think that's probably a nicer, easier rule for lawyers, actually, because I would say for me, I would be fundamentally conflicted representing anybody who was trying to destroy the earth or destroy nature or commit ecocide, because it would be like representing somebody who's trying to kill my family or kill my family, you know? And I don't think I could represent them to the best of my ability, because I fundamentally don't agree with what they are doing and have done. But yeah, I think it's a very interesting question whether this conscientious protector route could be used. And I mean, frankly, given the way that my career is developing, I might have the chance to put it into action sooner rather than later. So I can have a go and let you know.
Do you think you're going to be kicked off?
Sorry?
You think you're going to be kicked off?
I very much hope not. But, you know, I passionately believe in realigning the legal profession and to stop it working hand in hand with money to destroy the earth. And I think that's seen as a controversial position, even though it shouldn't be.
So what did you mean by the way my career is going?
Oh, I mean, just that I just do more and more radical things in a profession that doesn't appreciate radicalism. Like coming on a webinar which tells people that maybe they should, you know, consider being a conscientious protector. I think that would be seen as a radical thing. Obviously, I have at no point recommended people to break the law. That was Jojo saying it earlier. So
no, I get it. Thank you, Paul. And Jojo, you've got anything to add to that?
No, I think that was more one for Paul's particular sphere of expertise.
I agree. And the next one's from Marley Tosti. Can you report ecocide? And I think that's one for you, Jojo. Can you report ecocide to the local authorities / police?
Not at the moment. I mean, you can, but it wouldn't, you know, but because it's not on the statute book, so to speak. You know, in a sense, the whole point of our campaign is to make it, is to bring it into the criminal sphere in most of the world where it isn't yet. So there's that, and you know, it's an interesting one, because, you know, effectively what we're doing, specifically the countries that it will benefit the most effectively are those who are the most exploited. So the global south, the Pacific Islands in particular, obviously we've been specifically working with, because they're really at the sharp end of climate change, and they're effectively already going underwater, some of them, and so you know, it's logical in a sense that they've been the first ones to work with us and to move this forward. And we're also starting to make very good connections with indigenous groups as well. You know, this is something to be explored, but they have a very strong relationship to the concept of ecocide, because for them there are consequences if you damage Mother Earth, and so to have that, you know, reflected in the dominant legal system is potentially a very powerful thing. And I think what will also happen is that you'll end up with a gradual kind of marginalization of the polluting countries, because they will no longer be able to operate in those countries that ratify, you know, ecocide as a crime. And so, yeah, I think that, you know, while you can't right now, you know, tap a policeman on the shoulder or go to your local authority, you know, our hope and, you know, the way that we're working is that, you know, there will once, when this goes through, you know, it's going to be really with the support of, you know, a whole bunch of countries that are currently right now being, you know, that they're both the countries and the economically, and the people on the ground are being hugely exploited. So that's very much an important aspect of the work that we're doing.
Thank you, Jojo. And I'm assuming, Paul, that you have nothing to add on this.
Yeah.
And Fionn Thomas asks, what do you think will happen to recognition of being a conscientious protector as a human right after Brexit?
Could you just repeat that one?
What do you think will happen to recognition of being a conscientious protector as a human right after Brexit?
Is that a kind of what happens to the UK's subscription to the European Declaration on Human Rights?
I think so, yeah.
I mean, I believe we also subscribe to the Universal Declaration on Human Rights, so it shouldn't make a difference, because the Universal Declaration has it in there as well under Article 18.
Okay, thank you.
I hope that answers it.
This is a really interesting question. If we do offer funding, and this is from an anonymous person, how does it help?
Is this that one's to me, I guess. Yeah, so effectively there are a number of ways. In terms of the legal and diplomatic work, it's a question of, you know, having the wherewithal to, for example, you know, bring delegations from those smaller countries that wouldn't otherwise have a seat at the table to things like the International Criminal Court's annual assembly, which is precisely what we did for 4 years really, with Vanuatu and other island states, who simply would not have had the wherewithal to be there, had that not been facilitated practically, strategically, financially by the campaign. So it's a question of sort of getting the right people to the right tables is a big part of it. At the moment, on the legal side, we're convening an expert legal panel, an international one, with representatives from around the world, with specific expertise around international criminal law and environmental law, to draw together a workable, up-to-date, credible definition of ecocide as a crime that can be used, can be reviewed and used by those states that we're working with. And that in itself, for example, is quite an expensive process, because it involves, you know, key legal expertise. So there are the sort of very specific things on the legal and diplomatic side. And of course, there's the campaign side. I mean, a big aspect of what we do is about expanding narrative. It's about expanding conversation, and it's about making sure that the word ecocide and the concept of ecocide are spread as widely as possible. And that is effectively a campaigning issue, which essentially is about having the wherewithal to engage in that conversation, both media-wise, social media-wise, in terms of outreach and all of those things. So there's some very, very concrete things that, you know, funding can help with.
Okay. And if they chose to fund you, Paul, Lawyers for the Earth, how would it help?
To be honest, Lawyers for Nature doesn't actually, we're not actually requesting general funding. I mean, the way that we work is that if we represent individual tree protectors or river protectors, then we ask them to crowdfund. So basically, if you see a crowdfunder for people who are trying to get lawyers to protect nature, then do contribute to it on a case-by-case basis. And actually, we usually share those on our Twitter as well, which is @Law4Nature. So that's more for like individual case-by-case basis. So we don't have as much need for sort of systemic ongoing funding as the Stop Ecocide campaign does. They do sort of longer campaigning, as is like more on an individual basis.
Now, to all participants, it has now passed 9 o'clock. So if you need to go, feel free to go. And to the people who've been asking where to find the recording of this webinar, you can just email, and I'll post the email address. It'll be out in about 2 weeks, and you can get in touch on the email address I'm going to post now in the chat.
I can't wait to see whose email she's going to post. Okay, fair enough.
Is that the right one?
Yeah, I think that'll be fine. But also, I think you can probably, if you go to our social media channels and keep an eye on them and follow, like do a follow or sign up to our newsletter and so on, you will inevitably be notified of the fact that this is available. So, and if you go to the Stop Ecocide website, we have a whole section under media where you can find, podcasts and videos and so on, and it will end up on there once it's been edited. And I suspect or hope that XR might also potentially make it available, so or at least link to it. So I think it will certainly be available, and I think probably the timescale of a couple of weeks is probably about right. And I think we're probably going to actually have to wind up pretty soon. I'm happy to take maybe 2 more questions. And I did notice in the chat there's one thing that's been popping up quite a bit, which is about specific kinds of ecocides. And sometimes we do get asked, can you pronounce that this is an ecocide, or can you pronounce that that is an ecocide? Now, one of the things about this is that until it's actually in law, until it's been sort of agreed to go into the Rome Statute or so on, the exact definition won't be fixed, because as you can imagine, once the states kind of pile in to discuss this amendment to international law, there's probably going to be a bit of toing and froing. So it's very difficult to give a very precise definition at this moment, which is why we've got this whole legal panel working on a draft definition that can be used by states. That said, if you go to our website, you can see on Underwater's Ecocide, you can see a whole bunch of arenas where ecocide could potentially address some of the worst excesses of those different industries. But
okay, and I have posted the website in the chat, but if you don't know what it is, it's stopecocide.earth.
That's right, absolutely. And yeah, so we often steer a little bit clear of talking about particular ecocides on our social media feeds, because we'd be there all day and not do anything else, because there's so many, our entire global economic system right now is pretty much based on ecocide. So what we have to focus on is where law and the environment, where environmental justice and the law and ecocide are interacting, and where the word ecocide and the conversation around ecocide is expanding. So that kind of gives you a bit of a sense of what you'll find if you hook up to our social feeds and so on.
Okay, and it's not the next question, but it's a really interesting question from an anonymous attendee. What about if people have damaged property? As actions get more and more extreme, is there a risk of this undermining the progress of conscientious protector in law?
That's a really interesting one. And you'll notice that, in the description I gave earlier, that the absolute bottom line is that you're not harming anybody. We wouldn't, again, as we said earlier, we're not directly encouraging anybody to break a law anyway, because we seem to be doing that for obvious reasons. But at the same time, it would probably be down to the individual case, because, if you were to, as some of the Extinction Rebellion actions have, damaged property of organizations or departments that are seen to be either creating ecocide or failing to deal with it, there is potentially, and I'd love Paul to come back to me potentially on his thoughts on this, there is potentially grounds for still maintaining a conscientious protector stance, because effectively you're using a means of getting attention that is not damaging anybody, but is potentially drawing attention to a much bigger destruction. And so there's something in that narrative that is potentially usable. But I think, you know, it could depend on whose property you're damaging, what the motivation is, what the people who own that property are doing, in order for that to be to be more finely distinguished. I don't know what you think about that, Paul.
Yeah, I mean, my thought is that I'm slightly sad this question's come up right at the end of the webinar, because I could almost do a whole 2-hour webinar on the relationship between English property rights and environmental destruction. It's
We'll
very
do one on that.
the headline summary of it is that basically English law really prioritises property above private property above almost all other things, and actually that notion that is exported around the world is pretty much at the root of all the ecological and climate crisis, I think. And I think it's very fascinating what we do and don't regard as property that's worthy of protection. So, you know, someone who owns the land on which a 1,000-year-old oak grows can just chop it down because it's theirs. I don't agree with that. People can pump things into the atmosphere that will destroy other people's property in 50 years' time, and that's apparently fine. But if someone goes and shuts down a coal mine because by damaging a fence or something, that's somehow some big problem. I think it's odd. But obviously, again, I can't condone individual damage to property, but I think it's far more complex than the current legal system, both domestically and internationally, presents it as being. Yeah.
And actually, that's another opening for, you know, looking at the narrative, isn't it?
Yeah.
I think we've got a lot of people saying come back and do more on this in the chat.
It'd be good to pick up on some of these themes and do more detailed webinars on them. I've enjoyed doing this a lot, actually. It's been great.
Cool. Isn't there a legal minimum over which you can fight a court case? Like if you cause more than £5,000 worth of criminal damage?
I mean, criminal damage is one of those offences that's kind of triable either way. So if there is more than £5,000 worth of damage, you can choose to have a jury trial.
Okay.
So you can choose to go with the Crown Court thing, which obviously from the conscientious protection point of view is quite interesting, because it means that then the verdict is in the hands of a jury, not the hands of a judge.
Okay, thank you. And we've got a semi-complicated question. Well, it looks complicated, from David Morse. It seems that
because I think it's going to be the last one.
Conscientious protectors in ecocide have the capacity to draw previously isolated groups together to maximise their overall impact. Is this feasible? Is it an objective? And if so, any suggestions to how it might be achieved?
Okay, that's it. Could you just read that one again?
Certainly. It seems that conscientious protectors and ecocide have the capacity to draw previously isolated groups together to maximise their overall impact. Is this feasible? Is it an objective? And if so, any suggestions to how it might be achieved?
Absolutely. I would say this is absolutely an objective, both at the conscientious protector end and at the ecocide law end. I mean, and this speaks a little bit to what I was saying earlier about, you know, we may not have time to get everybody on board with our specific campaign, but to get people on board with the concept of criminalising mass damage to nature, in other words, of criminalising ecocide, that is something that we can and must do. And in fact, if you think about it, I mean, every environmental campaign out there, you know, would be helped by a crime of ecocide being in place. I have yet to encounter anybody that cared about anything to do with nature that would not be helped by this crime being in place. So, you know, in a way, we're not even in the business of trying to convert people. We're in the business, as this question kind of implies, of bringing people together and saying this is a kind of, you know, this is a piece that is a foundational piece for all of us and for all of you, you know, all of those who care. And so actually, you know, that's one of the reasons that we keep talking about it's the language you're using to speak about it. And actually, you know, I often describe our campaign as a bit of a one-trick pony. I mean, actually, it's got the extra trick of the conscientious protection, but the one-trick pony is making ecocide an international crime, and it's just a very good trick, because it is this piece that has the capacity to unlock so much else. You know, I mean, we're not under any illusion that criminalising ecocide is the one and only thing that needs doing to create a thriving Earth and a thriving, you know, society living on and in harmony with it. But without a crime of ecocide, it's kind of hard to see how that will be able to happen. So it's kind of a necessary but not sufficient piece. And I think the more people kind of understand that, and it literally revolves around this one word. So it's kind of simple. On one level, it's almost easy. It's like, let's just all use that word, because actually that has the potential to bring together people from so many different, political persuasions, or, the only thing that needs to be in common is you want a future for life on Earth and your children. It's as simple as that.
And wasn't it in the original Rome Statute before it got crossed out? The word ecocide, because
environmental destruction was definitely in there. It was actually, at one point it was designated under Article 26, and it got dropped with no vote. So in a way, this whole movement, this whole campaign is about reinstating a crime that should have been there 20 years ago. And can you just imagine what this world would have looked like if ecocide had been made a crime at the same time as war crimes and genocide? I mean, it's extraordinary, really.
Amazing.
Yeah, I just want to pick up on that same thought in relation to conscientious protectors, because as well as ecocide, I think what's amazing about the idea of conscientious protectors is that there are so many people working in so many different campaigns and for so many different causes, and actually we're all serving the same thing, really, which is conscientious protection for the Earth and life on Earth. And whichever way you're choosing to do that is valid. And I think there can sometimes be this kind of slight balkanization of the environmental movement. My campaign's more important than yours, and why are we not working on trees? Why are you not working on rivers? What about HS2? But actually everyone who is doing this kind of conscientious protectors work is doing an amazing thing. And it's just good to have a kind of term that binds us all together, from animal rights activists to tree rights to rivers to whatever it may be, to all be part of that thing. And to know that we are all working towards a common goal.
Lots of votes.
I guess I also want to end.
Jojo.
I realize I'm sort of broadcasting out to loads of people, is just to say that whatever you are doing in service of the Earth, thank you. We don't all see what we're each doing, but so many of you I can see are doing such wonderful things out there. Thank you for everything you've done as a conscientious protector and in service of the Earth, and may we all carry on doing that, and may we use this notion that there's so many other people who are consciously protecting to inspire us to keep on going.
And that is warmly seconded from me. Thank you to everybody out there standing up to protect the Earth and already being conscientious protectors. Thank you to Paul for joining me on this webinar. Thanks Alex for facilitating. And if you'd like to catch up on some of the key points we've been discussing, please visit our website stopecocide.earth, where you can find the information under Get Involved, Conscientious Protectors. And don't forget to sign up as an Earth Protector yourself, giving yourself access to the document that we were describing at the beginning of this session. If you have any specific questions, feel free to contact us via the website. Thank you, and bye for now.